All right, party peoples of the interwebs, it's another Sunday, so it's another pre-Sunday night law extravaganza stream where I'm going to talk about one subject that we're going to talk about in greater detail tonight. First of all, for those of you who don't know me, Viva Fry, former Montreal litigator turned current Florida rumbler, and I have just done the drive from Florida back to Quebec. It goes Florida, Georgia, South Carolina, North Carolina, what's after that? Virginia, then I think I go through Maryland, then New Jersey, then New York, then into the province of Quebec, and it feels like I am coming back behind the Iron Curtain, because I literally am coming back to behind the Iron Curtain. If anybody had any doubts as to how bad it is in Canada, I just saw a video from Rebel News earlier today. Alexa Lavoie, a journalist at Rebel News who's reporting from the McGill campus, the anti-Israel or pro-Palestine protests at the campus. Wait until you see this video. It seems that the cops in Quebec have strict stand-down orders to do nothing when it comes to Antifa thugs so that journalists can get harassed and assaulted and attempted theft, if I saw that video correctly. But if you haven't seen that video, enjoy it. And by enjoy, I mean get outraged by it.
But Rebel News, they call it! 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 Bye bye bye!
Puis la police, ça fait rien! La police! La police! Là, sérieusement, vous allez faire de quoi? Regardez, là! Je comprends pas le message. Qu'est-ce que vous comprenez pas? Là, ils ont la peinture. Regarde, là, ils sont en train de s'en aller dans le commerce.
I have come back to Canada for a brief period of time. There's an event in Toronto that I will be attending with Rebel News. But tonight we will be talking about a lot of issues, Supreme Court rulings that came down last week, not the immunity ruling, which has yet to come down and it's going to come down next week. But I saw a couple of pieces in the news to which I just had to say to myself and on Twitter, this is the way. The capital D Democrat left is waging what can only be described as the most insidious third world country, kangaroo republic, Eastern Europe type of lawfare against their leading political rivals. And a lot of people say fight fire with fire. I happen to believe that if you become the monster that you're trying to destroy, in defeating that monster, you don't defeat the monster, you just replace the monster. Do not fight lawfare with lawfare, because there is a certain element of injustice to the term lawfare. But it's about time that we are now seeing certain states, certain attorney generals fighting fire with fire, in that they are fighting injustice with justice. Kansas is suing Pfizer. A number of states have joined in an amicus brief to contest Donald Trump's gag order out of D.C. And Donald Trump has made a renewed motion for the recusal of New York Nipple Judge Arthur Engeron in the New York Letitia James $500 million penalty disgorgement case. Two cases somewhat intertwined. In the D.C. case, you will recall that Judge Chutkan has gagged Donald Trump with a form of prior restraint, gagging a defendant in the context of ongoing litigation, in the context of the 2024 election cycle, and a number of states have now joined suit or filed an amicus brief contesting Judge Chutkan's gag order on Donald Trump. And here you have the brief for amici curiae: Iowa, West Virginia, Alabama, Alaska, Idaho, Indiana, Kansas, Kentucky, Louisiana, Mississippi, Missouri, Nebraska, South Dakota, Texas, and Utah supporting defendant and reversal. These states have filed an amicus curiae, an amicus brief, asking to be recognized as a friend of the court so that they can contest the gag order against Donald Trump. And they are actually raising similar arguments to the arguments raised by Joe Neerman, Good Logic in New York. They're saying that we all have an interest in allowing Donald Trump to speak, and they're raising a number of arguments for which the gag order is unconstitutional, vague, etc., etc. I'll highlight just a few of those arguments before we move on to New York Nipple Judge Engeron and the corruption out of New York. The district court did not narrowly tailor its prior restraint to prevent imminent threats against individuals that would interfere with the administration of justice. The order does not satisfy the strict scrutiny required to justify prior restraints. Interference with the ongoing presidential election weighs against a prior restraint in general and against this vague, overbroad order in general. The gag orders against Donald Trump have been so wildly outrageous, so unjustified, so not narrowly tailored. In this amicus, the states petitioning the court to reverse the gag order are arguing all of this. The basis for the gag orders was that Trump, when he makes public statements, it results in threats to the judges, the judiciary, the prosecutors, etc., etc. That's what Judge Engeron said out of New York. When in reality, there's no clear clear connection between any threats that the court might get, and I say any threats, I'll put it in quotes because I don't think that they're talking about bona fide threats. There's no nexus between Trump's public statements and any threats the court might get. In fact, I would argue that they are probably getting even more threats because of the gag orders that they're issuing, in which case the gag orders make absolutely no sense. But the bottom line, there has been no risk of imminent threat to individuals, to witnesses, etc., to possibly justify a gag order against Trump. And then we get into the prior restraint, and you'll recall the cornerstone decision as relates to prior restraint was the New York Times that had obtained classified information as relates to military secrets in the context of a war, and the government sought prior restraint enjoining the New York Times from publishing those the Pentagon Papers. The government sought prior restraint enjoining New York Times from publishing those papers, and even in that case, the court came to the conclusion that no, prior restraint is not justified in this context, and yet somehow in Trump's case, they have gotten prior restraint, preventing Donald Trump from talking about his own ongoing criminal proceedings in the context of an election year when he is the leading candidate, and somehow Judge Chutkan authorized the gag order on the basis of prior restraint. It makes absolutely no sense, and at least some states now are finally stepping up to the bat, the legal bat, to petition the court to say this makes no sense and we have an interest in having this decision overturned. And they allege vagueness, and it is obviously too vague. I mean, they allege that it's so vague, the decision itself is contradictory in that Donald Trump can't make any statements as relates to intimidating potential witnesses, and yet at the very same time can criticize the policies of his witnesses or of the potential witnesses. It makes no sense. It never made any sense. It was always about gagging Trump and bogging him down in an election cycle in the hopes of suppressing his ability to campaign. Little did they understand, these idiots on the left, capital D Democrats, they do not understand the Streisand effect. Barbara Streisand herself doesn't understand the Streisand effect. The more they try to shut down Trump through injustices like this, the more they're going to make him more popular and make his message resonate among people who might not have ever heard it in the first place. And while we're on the issue of judicial corruption, more corruption has been revealed from New York Nipple judge Arthur Engeron, the judge who boasted 10 years ago to a group of journalists how he had the judicial tools to come to whatever decision he wants to, how he can distinguish cases from the current case, how he can bypass jury decisions or override them entirely in the event that a jury comes to a decision that he doesn't like. He was caught on camera saying that 10 years ago. He carried out those very same strategies in the context of the prosecution, or I will say the persecution against Donald Trump. Well, aside from being a biased, corrupt hack, it seems that he's just objectively corrupt, because it was recently revealed that he had unlawful or allegedly unlawful ex parte communications with a person who was not party to the suit and never disclosed it to any of the parties to the suit. That individual is someone named Adam Bailey, a New York real estate attorney who the day Arthur Engeron issued his ruling against Donald Trump was on CBS News bragging about how he, weeks earlier, had seen Arthur Engeron in the courthouse, said to his client, I gotta go talk to the judge, went and met with Arthur Engeron, talked to him about his upcoming ruling, and not only talked to him about the upcoming ruling, gave him advice on how to issue that ruling properly, because as he said in that interview, he wanted to make sure Arthur Engeron got that decision right. And he apparently advised the judge in the weeks leading up to the decision, and the day Arthur Engeron issued his ruling, he was boasting about his meeting with Arthur Engeron to mainstream media news who didn't understand the gravity of what he was admitting to in real time. It's not just corruption, it's arrogance and stupidity, it's haughtiness. They don't think there's anything wrong with what they're doing, to the point where they get up in mainstream media, legacy media, and talk about their corruption, their overt corruption. And now Donald Trump heard this, and he's made a motion for recusal of New York Nipple judge Arthur Engeron on the basis that this is an unlawful, unethical ex parte communication with someone who is not a party to the proceeding and it was never disclosed to any of the parties of the proceedings. And lo and behold, 3 weeks after this meeting, Judge Arthur Engeron issues the ruling, and I have no doubt that Adam Bailey, the New York real estate attorney who has sued Donald Trump multiple times, was very, very happy with Arthur Engeron's ruling. And apparently it was so unethical that Arthur Engeron is now under investigation by whatever ethics committee or body that exists in New York State. I wouldn't hold my breath for that, because the entire state of New York is corrupt. Take your stuff, get the heck out of New York. But bottom line, Trump has made a motion for recusal of the judge. The judge still has authority over certain elements of the case. It's not because the ruling has been issued that the judge no longer has any authority in the case. But bottom line, corruption has been exposed. It is corruption through and through. It's not turtles all the way down when it comes to New York, when it comes to Georgia, it is corruption all the way down. We are witnessing it in real time, and it is time to fight back through legitimate lawfare, and it seems that some states are doing that. It seems that some state attorney generals are doing that, and we will hope that the courts get it right sooner than later. And even if they don't, at the very least, they are exposing this corruption for the world to see, and I dare say the world is seeing it, the world is appreciating it, and the world is saying we have had enough of it. With that said, if you like what I do, you know what to do. Like, share, subscribe. Make sure your notifications are turned on. When I put up a video, if you're so inclined, just make sure to drop a thumbs up, a comment, and if you don't like it, drop a thumbs down and drop a comment as to why you didn't like it. But more important than anything, exercise, eat healthy, talk to people in real life. Sunlight, even though there's not as much sunlight up here in Quebec as there is in Florida. See you tonight, 6 o'clock every Sunday night. Robert Barnes, Viva Fry, Law Extravaganza, and now you know you vlog. Peace out, peeps. Booyah!
I had one last thing to say about tools. I get a lot of what I do involves motions. These summary judgment motions I mentioned. And all right, am I following the law or am I making law? Okay, I'm following law. I'm an impartial referee, but it's hard to factor out my own emotions. And I have tools. Somebody can say, well, Your Honor, you have to throw out this case because it's just like another case. Well, is it just like another case? What if the defendant was wearing a red sweater instead of a blue sweater? Well, that's an extreme example. That wouldn't distinguish most cases, but there are other facts that do. Maybe the education of somebody who supposedly entered into a contract would decide whether the contract was binding. I have a tool that I'll call what I'll call a tool called estoppel. Somebody makes an argument and I say, you can't make that argument. You made a different argument 3 months ago in this case, or even in another case. So I wish you all luck. I'll stand here or around afterwards for questions. And again, thanks to the administration for having me.